closing arguments. In Moscow, Idaho, the man accused of killing 4 University of Idaho students last November is back in court, staying silent as a judge entered not guilty pleas on his behalf for burglary and 4 counts of first-degree murder. Our crew is live outside of the courthouse with the latest from Bryan Kohberger's appearance.
What you do need to remember, though, is that anything you do say, other than to your lawyers, could be used against you in a later court proceeding. Do you understand that?
Yes, I do.
In Salt Lake City, Utah, the author of a children's book about grieving, accused of killing her husband. Prosecutors say Corey Richens poisoned her husband, Eric, with a lethal dose of fentanyl in March of 2022. Tonight, we break down the details of the accusations against this mother of 3.
I mean, I can give you 3 good reasons that he stuck around, and they're all under the age of 10. He lived for his boys. He would have done anything for his boys.
On the docket tonight, disgraced former attorney Alec Murdaugh was convicted of the murders of his wife and son, but his legal troubles are far from over. Tonight, we will be breaking down new filings in the civil case connected to the 2019 boat crash that killed Mallory Beach.
But I can tell you that at that time, and as I sit here today, that I believe that boat wreck is the reason why Pawpaw and Maggie were killed. Okay. And I'm certain, I believe that.
In tonight's Tank Takes, a teen is arrested after driving 176 miles per hour on the interstate. But when he's pulled over, he tells officers he was actually going 183 miles per hour. So tonight, we're asking our think tank, what speed should the officer report? This hour of closing arguments starts right now. And welcome back to Closing Arguments. I'm Julia Janae, in tonight for Vinnie Politan, who's on assignment for his court TV series, Accomplice to Murder. Today in Moscow, Idaho, it was a huge arraignment day for the man who's accused in the stabbing deaths of 4 University of Idaho students. Bryan Kohberger appeared in court today for his arraignment, and it came with a couple of surprises. He was indicted, remember, through a secret grand jury on 4 counts of first-degree murder and 1 count of burglary. And today, we briefly heard his voice. The judge asked him some questions. He was with his attorney, and then the attorney made the plea in the case, informing the court that the client would be standing silent. The judge entered not guilty pleas on Kohberger's behalf. For more on what happened today, though, let's bring in to this conversation our very own Court TV legal correspondent, Kaylee Painter, who has been there the entire day. Now she's live outside of the courthouse in Moscow, Idaho. Kaylee, tell us about his demeanor in court today and this notion of standing silent.
Yeah, great to be with you, Julia. It has been a long day for everyone here. The line started forming at 3 a.m. local time for a seat inside that courtroom, and all eyes were on the door that we expected Bryan Kohberger to enter for his arraignment. It was a packed house, of course, inside that courtroom, and he enters, as you can see there. His ankles are shackled. He seemed calm as a cucumber, really, not really fazed by anything. He was stoic. He sat there, sometimes kind of slumped over a little bit, and he paid attention. As the judge read the indictment and his rights to him, he would nod occasionally. He also had a hard copy of the indictment in front of him at counsel table, and I was sitting on the front row for the public right behind a counsel table, and he would flip the pages with the judge as the judge read them to everyone in the courtroom. And when he was asked to speak, he did so. It was direct and it was sharp sounding. He was almost trying to sound confident, it seemed, as he spoke to the judge throughout this time. But what a moment, really a lot of glares in his direction from those in the gallery, Julia.
You see some smiles there that he cast to his attorney. Can you explain what the impact of this standing silent plea is? Is it any different than not guilty for his defense?
Yeah, you're right. It's tantamount to a not guilty plea. So this case moves forward as though his attorney entered a not guilty plea on his behalf. But it is interesting, strategic move. In fact, let's go back and watch that moment as it unfolded earlier.
Your Honor, we will be standing silent.
Okay, because Mr. Kohberger is standing silent, I'm going to enter not guilty pleas on each charge, counts 1, 2, 3, 4, and 5.
That was unexpected for a lot of people here at the courthouse and really public who've been following this case. It's not something, as we discussed earlier, Julia, that you commonly see in cases like this. Usually a defendant enters guilty or not guilty, and it's the defendant, maybe the one saying that. But here in Idaho, the attorney puts forth the plea and chose to stand silent. We'll see how that unfolds as this case continues in the system.
Yeah, sometimes I've seen it where the defendant will stand silent, but the attorney will input the not guilty plea. We'll talk about that more in a moment, but let's talk about the death penalty in this case. I know it's on the minds of a lot of people who are invested in this case. Is it still on the table? What are you hearing behind the scenes on whether or not he is going to face the death penalty?
Absolutely, it is still on the table. In fact, 60 days from today, it's around August, prosecutors have that much time in which to file a court document. It's called a notice to seek the death penalty, where they have to allege the certain aggravating factors under the law, such as it's a heinous, cold, calculated crime, the number of victims for here. In this case, it is something that the community expects, and the judge even listed as one of the possibilities. Let's watch.
If you are found guilty or plead guilty on each charge, and the maximum sentences are imposed consecutively, that means one right after the other, you could be facing 10 years in prison, followed by 4 consecutive life sentences or death penalties, fines of up to $200,000 and $20,000 to be paid directly to the families with any restitution resulting from the crimes.
And that first 10-year possibility, Julia, that's for the burglary count 1 in this indictment, because prosecutors allege that he broke into that home in the middle of the night, early morning hours, around 4 a.m. is what we know. And then the remaining 4 counts, obviously first-degree murder, which maximum punishment would be that death penalty. The family of Kaylee Goncalves at least has spoken out, and they hope that the prosecution does seek the death penalty here.
Wow. In the event it's not a death penalty case, do you know when we can expect this trial to begin? And if you know, do you know if he plans to waive his right to a speedy trial, or if he's done that already?
He hasn't done that already. He did waive his right to the speedy preliminary hearing that usually happens within 14 days of his first appearance, back in January. He waived that. Of course, that was set in June, but prosecutors behind closed doors sought this grand jury indictment, which eliminated the need, as you know, of that preliminary hearing. So that was formally vacated today due to this indictment, and now his formal arraignment. He's in district court with the new judge, great name there. And so what we know is that as this moves forward, we will likely see this trial continued, as what the speculation is, to be honest, Julia, because the death penalty could be sought. They could ask for a change of venue on behalf of the defense. But right now, it is set for October 2nd of this year, which is within 1 year of this mass murder that happened November 13th of last year. It's scheduled for 6 weeks, which would end or conclude right before or around that 1 year anniversary, maybe some sort of justice before that 1 year marking. And that's kind of what happened in Waukesha, Wisconsin. They wanted to make sure they had that trial before the anniversary of that event. So maybe that's what the goal is here. But as of now, Julia, as you said, they have not waived a speedy trial, so we'll just have to wait and see.
Chandler Painter, you always have all of the answers. Thank you so much for joining us tonight, always keeping us up to date with everything that's happened in this case. Get some rest. I know it's a little bit cold out there, so stay warm. And let's bring in the think tank to get their thoughts on this trial. Joining us tonight is my honor to be with, in Englewood Cliffs, New Jersey, criminal defense attorney and former prosecutor Al Wunsch III. And joining us from Stamford, Connecticut, criminal defense attorney Darnell Crossland. And in Philadelphia, Pennsylvania, family law attorney Jennifer Brandt. Thank you all for being here. So good to see you on while Vinny is off today. But Al, let me start with you. He stood silent in court today. What could that mean in your estimation?
I think it's just a defiance thing. I think it's all for show. It's really no difference between saying that and not guilty. And it just looks like he and his defense counsel are unified in their position, and that they're going forward. and that they're looking forward to the trial and that they're ready to go. And it's going to be a battle, which I wouldn't expect it to be other than that. Does it mean anything in the long run? Nothing. It doesn't mean anything in the short run? Nothing. It's just a defiance act. It's his way of just basically, thumbing his nose at the system, so to speak. I wasn't overly taken by it.
Darnell, do you think this shows cohesion between him and his public defender, or is this something that a defendant decides he's going to do and the attorney has to acquiesce to it?
Yeah, actually, I don't think it shows any cohesion. I think what it's doing is saying that he wants to make a point that he has a right to remain silent. He has no burden in this fight. They brought the charges, let them prove them. And he's starting to show that from the first day, saying it's your burden, you got to carry that, you do everything. In fact, he might be showing a little less faith in the public defender because he's a smart aleck. So he's probably going to end up doing like Waukesha and taking over this trial anyway. So he's starting by saying, you know what, I'm setting the tone. You bring these charges, you prove them, and then he's probably going to fire his lawyer later.
It did stick out to me, even though this is a common thing the judge says, when they let the defendant know that they have a right to counsel, they also have a right to represent themselves. We will see what happens with him. Emily, the only time that I have ever seen someone stand silent is in the Parkland school shooter case with Nicholas Cruz. And this was done via writing, so it wasn't a situation where we heard him say that he was going to stand silent, but he didn't say anything, and his attorneys put in this plea, first of not guilty, then they withdrew it, saying that it actually should have been stand silent, and then we know eventually he admitted to these murders and he pleaded guilty. But in that situation, we talked a lot about thinking that this could be him trying to show remorse because we know he wanted to plead guilty. Do you think that could be at all, and I apologize for saying Emily, I meant to say Jennifer. Jennifer, do you think at all that that could be part of this decision not to say one way or the other in front of the judge when we know it's common to say not guilty?
No, I don't think it shows remorse at all. In fact, I think it shows, as Darnell pointed out, I think this guy is a smart aleck. I think he thinks he knows better than anyone else. And I think it's almost like he's thumbing his nose at the legal system. I'm not going to say anything. I'm not going to give anyone the satisfaction of making any claim at this point in time. I'm just going to sit here and let you prove it wrong, prove me wrong, prove me guilty, and bring all your charges and bring all your evidence against me. So I think he's very calculating, just the way he sat there, how engaged he was in this whole proceeding. It seems like he's very involved, and also that he may be calling the shots as to how he wants his defense carried out.
Al, do you think that he will be waiving his right to a speedy trial? Do you think he wants it to be in October, which it is currently set for?
Well, speedy trial is a misnomer. I mean, anyone who does defense work will tell you the longer it takes, the harder it is for the state to put their case together. So, I mean, he may not be happy sitting in a jail cell, but in my opinion, when you have a situation that you can drag on as long as you want, it always benefits the defense. And that may be the situation here. I always waive a speedy trial in most instances, but most of the times my clients are not sitting in a cell. He's obviously there. Maybe he wants to get moving on this, but give as much time as possible. A lot of things can happen to the state's case over time.
Now, we know if the death penalty is put on the table, that could change things. In Idaho, it's 6 months from arraignment, so that put us around November. If he didn't waive his right, that we would still have to go to a trial. But Darnell, right now, people in the community, they're concerned that this is going to run into, if the trial goes forward as it stands, October 2nd, and then 6 weeks of trial, it could run into the anniversary of this horrific tragedy. Should the judge keep that in mind when setting this date?
Absolutely not. I mean, if it works out that, there's some sort of justification or vindication, if you would, for this trial happening on or before the anniversary, then great. But I think that what's most important is that the discovery is exchanged, any type of Brady or any type of material is exchanged, that all the parties get all the discovery they need. And I think that's what's most important. The judge shouldn't rush to judgment. He shouldn't rush to trial. He can't rush to trial. And so I don't think it should play a part at all. In terms of speedy trial, though, I will tell you that this guy looks like the type of guy that wants a speedy trial, because he doesn't want to let it drag out and let them think that they're comfortable and they're getting things together. He wants to disturb that whole apple cart. And I've been fighting for speedy trial for the last 3 months on a case I have here, State versus Pino, and I've got into some heavy arguments with the judge, because if they don't bring you in 30 days, then you have a right to make a motion for dismissal. I've done that, and we still haven't gotten a dismissal. So I think he's probably going to push this forward, and then he's going to probably be hoping that they're not ready, and he's going to probably trying to find a way to get this stuff thrown out.
Could be hoping for a dismissal. Who knows? Think Tank, thanks for sticking around. We have more coming up next.